Thank you very much. Just wanted to give a brief overview of the content of the presentation. Before I actually get into the act, as I did the last time, I wanted to provide background to how the act originated or why the act originated, probably better said, and for us to get a better understanding of our obligations, international obligations, which is the purpose behind the act. So that will take a few slides, maybe about four of those slides, and then we get into the content of the act itself. The last time I tried to hyperlink the application form and the risk-based questionnaire, which was a technical challenge. So what I am proposing to do is probably at the end of the presentation to bring it up, or maybe during to bring it up, not to actually go through it in any great detail, but just to show your participants what it looks like for when they have to proceed with their registration or conversion to non-profit organization status. Okay, so this is the background that I just spoke about to the Non-Profit Organization Act. So it originated from our obligations with the Financial Action Task Force, sorry, and I'm sure all of your participants would be aware of what FATF represents. And I have a brief description there, it being the intergovernmental agencies that sets global standards for enforcement of legislation relating to money laundering, terrorist financing, and of course the financing, the proliferation of weapons of mass destruction. And of course, you may be wondering what this has to do with non-profit organizations, which with a clarity will be provided for in a bit. Now, under FATF, there were 40 recommendations that were issued by the organizations to all countries. So all countries were required to implement these 40 recommendations. The Non-Profit Organizations Act relates to one of those recommendations, which I would come to in a bit. In 2019, our country, Trinidad and Tobago, was evaluated to determine our level of adoption of these 40 recommendations and to assess our exposure to money laundering issues and, of course, all of the other concerns relating to money laundering. We were found to be non-compliant in two recommendations, in that we had done nothing legislatively to implement two of those recommendations. That's recommendation 7 and recommendation 8. We were found to be partially compliant in 13 recommendations, in sense that legislation was passed for 13 recommendations, but no administrative framework was set up to ensure the adequate implementation of those 13 recommendations. And then we were found to have low or moderate level of effectiveness in our immediate outcomes, which means that from the state side, we were very low or moderately enforcing the implementation of these recommendations. So in this public notice that was issued in February of last year, Trinidad and Tobago was identified with several countries who have severe deficiencies with the implementation of these recommendations. And you would see names of those countries there, some of which you really would not want to be in a group with. So taking that into account, it was the impetus to forcefully move towards changing our status quo from being gray listed, which we were last year, for those of you who are in the banking sector would have known that, to becoming non-gray listed. So if you are gray listed, it means that there are issues with your financial institutions being able to conduct international business and international trade with other international financial organizations. So in February of 2019, the European Commission published its report, and it lists those countries that had weak anti-money laundering and terrorist financing regimes. And of course, as I said, Trinidad and Tobago was identified as one of those, with other countries like Botswana, Ethiopia, Ghana, and the like. So the failure for us in complying with these recommendations signaled to the world is a perception that we were indeed a safe haven for money laundering, financing of terrorism and financing the proliferation of mass destruction, and something we don't want. So it may not have been a reality, but just by the mere fact that we did not implement these 40 recommendations effectively, this is what it signaled to the world. And being gray listed meant that there were severe outcomes, consequences. As I said, those in the banking community would have been adequately aware of that. And some of these negative outcomes would result in stuff like reduction in trade, problems with our international loans, downgrading in our ratings, and of course, blacklistings, which could lead to economic sanctions. So thankfully, we did not reach to that result, because what happened in March of 2019, and I will show you the progression of this act. In March of 2019 is when this legislation was drafted, and in the space of 4 to 6 weeks, it became law. So remember, I would have said about 2 slides earlier that there were 2 recommendations that we did not implement at all, recommendation 7 and recommendation 8. This is what recommendation 8 relates to. So recommendation 8 specifically relates to implementing a regime to deal with non-profit organizations. And it states that countries should review the adequacy of their laws and regulations as it relates to non-profit organizations, which the country has identified as being vulnerable to terrorist financing abuse, and the country should apply focused and proportionate measures in line with risk-based approach to such non-profit organizations to protect them from terrorist financing. And these include, of course, terrorist organizations posing as legitimate entities by exploiting legitimate entities to be conduits for terrorist financing, and of course, concealing, obscuring clandestine diversion of funds. So now I'm able to tie in what I said earlier about Trinidad and Tobago, the perception of us being viewed as a safe haven for terrorist financing and financing the proliferations of mass destruction. So yes, we don't have an issue with weapons of mass destruction passing through Trinidad and Tobago. We financing it. But the reality is that terrorists or persons who are involved in terrorist activities to circumvent their identity will be able to hide or masquerade themselves behind a very legitimate entity. And the easiest one to choose to do that is a non-profit organization or body that is supposedly established for carrying out charitable works, social activity, and masquerade themselves behind that entity to filter money towards the proliferation of weapons of mass destruction and money laundering. So that is the basis behind this legislation. Only because the weakness was identified with these non-profit organizations, and it was seen as an ability for persons with ill intent to use these entities to further their activities. So this is how we were to implement this recommendation, recommendation 8, right? We were to identify our non-profit organization subset and realize that it was a vulnerable group to financing abuse. Just as I explained to you just now, we were to review the adequacy of our laws that were in place and what regulations we had relating to that subset. We were to do adequacy checks to identify the nature of terrorist financing, the threats, and must consider the adequacy of other risk mitigation measures, including policies and working, of course, more closely with the NPO sector. And then we were to impose standards, not mandatory standards, but standards that can be reviewed to ensure adequate monitoring of the particular sector. What FATF indicated, if the standards were too extensive or too onerous, then they would be considered to be deficient. Why? Because the NPOs are generally non-profit companies. So if you have a standard for them to adhere to that becomes expensive, it becomes inadequate and there would be no adherence. So you would see some of the requirements when I get into the act that really might be considered to be extremely extensive for a particular NPO. So FATF indicated that the standard cannot be too exhaustive, too extensive, or onerous, because then there will be no compliance and it will be a deficiency. Recommendation 8 works in conjunction with two other recommendations, recommendations 25 and recommendations 24. I'm just going to give you a little tidbit here. Those two recommendations, 24 and 25, they relate to transparency of the beneficial ownership of legal persons. And I don't know if you recall that simultaneously or just before, prior to the passage of this act, we also enacted an amendment to the Companies Act. The amendment to the Companies Act preceded this NPO legislation. And then we also enacted the Civil Asset Recovery Act. That has a very long name, you know. So the short version is the Civil Asset Recovery. So the Civil Asset Recovery Act, the Companies Amendment Act were enacted specifically to address recommendation 24 and 25, which relate to transparency of beneficial ownership. The idea was to be able to trace persons who hide behind companies and hide their assets, especially if you're trying to follow or determine if those assets were the result of money laundering, financing of weapons of mass destruction, and the like. So, you know, the Attorney General had his tagline, "Follow the money," that he came up with last year. So these two pieces of legislation were a result of that recommendation. So that's why recommendation 8, recommendation 24, and recommendation 25 work in tandem in being able to stop that gap as it relates to the ability to either hide your assets or filter money through a social group, a social purpose, being a non-profit organization. So I don't need to go into any great detail in terms of recommendation 24 and 25. It was just simply to tie these three of them together for you. So let's get straight into our purpose. So recommendation 8 comes from our requirements under the POCA legislation, which is the Proceeds of Crime Act. And you know, the Proceeds of Crime Act is part of a body of legislation, the FIU, the Financial Intelligence Unit Act, the Financial Intelligence Unit Regulations, the Terrorist Financing Regulations. It's about 5 pieces of legislation that relate to our implementation of the Proceeds of Crime Act. So just to pull out some key sections of this act for you, which is the Proceeds of Crime Act, for you to understand what your exposure is once you are involved in non-profit organization work. It ties in together. So if you are found guilty of a money laundering offense, your liability is a fine of $25 million and 15 years imprisonment. And if you fail to disclose your knowledge or suspicion of a money laundering offense, your fine is $250,000 and 3 years imprisonment. If you fail to make a suspicious transaction report or suspicious activity report to the Financial Intelligence Unit, your fine is $500,000 and 2 years imprisonment. This is on summary conviction, and if it's on indictable conviction, your years at the state location can go up to 7 years. If you are involved in financing of terrorism, that's penalty of 25 years imprisonment, and then failure to disclose information relating to property used for the commission of any offenses under the Anti-Terrorism Act to the FIU, your penalty or liability is 5 years imprisonment. Why is this important? This is important. These are offenses under the Proceeds of Crime Act. Why is this important? This is important because non-profit organizations are now categorized under the Proceeds of Crime Act as a listed business. It becomes a listed business because it falls under the ambit of the Financial Intelligence Unit for supervision. So my business, I am in the business of legal service provision, and the type of legal work that I do, because not every lawyer is classified under listed business under the first schedule of the Proceeds of Crime Act. but the nature of my legal business falls under that act because the type of legal work I do. So the type of legal work I do brings me in line with this exposure. So if it is found that I know or I am suspicious that one of my clients is involved in money laundering activities and I fail to disclose that to the FIU, I am exposed to a fine of 250,000 and 3 years imprisonment. Or if I fail to make a suspicious activity report or suspicious transaction report to the FIU, that is my fine. Similarly, persons who are involved in a non-profit organization, if your benefactors, and we're going to come to that in a little bit, your contributions, and you have that knowledge and you fail to make that disclosure, or you have that suspicion and you fail to make that disclosure to the Financial Intelligence Unit, you have a similar exposure as I do. So that's why we tie in the Proceeds of Crime Act with non-profit organizations. You may have some questions and I will answer them, a bit later. So let's get into the Non-Profit Organizations Act quickly. I have to follow from my printed thing because the screen with all of the participants is halfway on my PowerPoint. So a non-profit organization is defined as an association or group of persons, organized for a particular purpose other than to generate income. So remember when I said an NPO is not a company trading for profit? Because that's the idea, it's non-profit. So the purpose for which it was formed, the purpose for which the group of persons came together is not to generate profit or income. It doesn't mean that they don't make money. Some do. Some of the biggest international NPOs are making huge amounts of profits, much more than probably Coca-Cola and some other trading companies. But the purpose for which the company, non-profit organization was formed, or the purpose for which the group came together was not to earn, to make a profit. It was for a particular purpose. And I will get into what those purposes are in a bit. So NPOs in the past, not now, so we're dealing with before and now, right? So NPOs in the past were classified into two categories. We had an unincorporated association and we have an incorporated association. So an unincorporated association is a group of persons who come together without any legal structure to advance a particular purpose. So let's take an example. A group of housewives in a village, a fishing village of Moruga. They decide that there is this extremely intelligent kid in their village who has the potential of going to Yale or Harvard or some university. And they come together to raise funds to assist with his educational purposes. There's no legal structure there. They're all the way down in Moruga. They don't know anything about going by no lawyer and incorporating a company and the like. But they come together and they meet. They have a purpose and they raise funds for that purpose. They raise funds to advance that cause to ensure that this child receives his education right up until university. That is an unincorporated association. It's a group of persons that came together without legal structure to advance a particular purpose, right? The incorporated associations, on the other hand, is a legally structured body. So it's a body or a group with certain corporate attributes. And in Trinidad and Tobago, an incorporated association could have only been incorporated under the Companies Act as a non-profit company. So if you wanted to have that corporate structure, you had to form yourself into a legal body as a non-profit company under the Companies Act. So you have to go through the regimes of the Companies Act and incorporate a non-profit company. And that is what distinguishes an unincorporated association from an incorporated association. But the similarity between both is that whether it is unincorporated or it is incorporated, the purpose for coming together was not for profit or gain, but to advance a particular purpose, right? So So let's get into what those purposes are. Did I go too far? Hold on, bear with me. Right, purposes of NPOs. So the purposes are the advancement, promotion of, and just pay attention to some of these words that because you would see how far and wide the NPO Act reaches, okay? The promotion or advancement of a patriotic, religious, philanthropic, charitable, educational, cultural, scientific, literary, historical, artistic, social, professional, fraternal, sporting, or athletic purpose or some other useful objectives. So in terms of the purpose of which that group, whether incorporated or unincorporated, can come together, very wide. In the main really is for some social purpose, a purpose that advances a cause, whether it's religious, whether it's sporting or educational, but it advances a cause. That is the purpose that you came together for. And people would have asked me when I did this presentation to previous groups whether or not religious bodies are included. And it's right there, patriotic, religious. So persons who came together for a religious purposes, which are religious bodies, a lot of our religious groups are like that, they are now under the ambit of the Non-Profit Organizations Act and are required, they must require or are required to comply with the provisions of the Act. Yeah. So this is what I was telling you, the speed by which this Act came about. And remember, it came on the heels of us being gray listed. And we were gray listed for several reasons that I identified before. One of which is that we had done absolutely nothing to implement Recommendation 8, which relates to non-profit organizations. So the bill was introduced in Parliament in March 2019 and passed in April 2019 and assented to in June 2019. So very quickly and hurriedly, as some of us may think, in terms of getting this particular act on our books. Of course, the proof of the pudding is in eating. So it's now the actual administrative workability of the act, because passing the act and having it on the books are one thing, it is ensuring that the act is adhered to. And I guess that's why, you guys are on this particular webinar. So the act really relates to the supervision, the registration first, and supervision of all non-profit organizations in Trinidad and Tobago. And this is how it works. Those bodies that were non-profit organizations before the act came into force, which is in 2019, are required to take certain steps to regularize their status. And those persons who are desirous of forming themselves into a non-profit organization are required to take certain steps to ensure that they adhere to the provisions of the Act. So the Act defines an NPO as a body of persons, whether incorporated or unincorporated. We went through that already, which is established for the purposes, and the same purposes I read out for you. And the purposes that I read out for you 2 slides prior were actually taken from the Companies Act, Section 308, which deals with the incorporation of a non-profit company. So what they did under the NPO Act was just to pull that definition and put it into the Non-Profit Organization Act. And of course, carries out its business without pecuniary gain. We discussed that. And restricts the use of its profits or other accretions to the promotion of its purpose or its objects. Yes? All non-profit organizations, which I just explained to you, save friendly societies, must be registered as an NPO. That is under Section 5(1) of the Act. So all those that were in formation before and those that are seeking to form themselves now must be registered under the Act as an NPO. Any person who carries out the activities of a non-profit organization that isn't registered under the Act is liable on commits an offense, first off, you're committing an offense to carry out your non-profit business, and you are liable on conviction to a fine of $50,000 and imprisonment for 5 years. It's not an either or, both fine and imprisonment. So the moral of the story is, if you are looking to continue your social work, whatever it be, in whatever sphere, you have to get yourself organized under the particular act. Failing to do that means that you are committing an offense. Now, you might be doing a good. You know, the villagers that we spoke of in Moruga who want to get this young lad off the university, that's a good purpose. That is commendable. But once they decide to do that and they're not registered as an NPO, it's an offense. And I'll go a little further in about 2 slides down. When you try to even get people to donate money, so you go on, you do your collection and ask people to contribute to that cause, it is a further offense, and there are serious repercussions to that. NPOs that are currently registered as non-profit companies under the Act, the Registrar General would have transitioned those non-profit companies to its register of NPOs, but those companies are required to fulfill certain mandates to complete that registration purpose. So basically, a non-profit company doesn't have to apply for registration. That non-profit company, once it was legally registered under the Companies Act, will be transitioned to the register of NPOs. But to complete the registration process, the directors of that company are required to submit certain documentation to the company's registry, to the Registrar General's department, to fulfill its obligations under the Act. And originally, the Act had said 1 year from the date of commencement. So the Act commenced or came into force, as I told you, June of 2019. So you would have had until June of 2020 to do that, failing which it was an offense. However, that June date has been extended. It was first extended to September 30th. We got an extension to September, and I think a week ago, the Attorney General gave a further extension to the 31st of December. But you know, Trinis, we love the last minute thing. So they will wait until the 29th of December or the 30th of December and line up in a long queue running from Registrar General's office straight up to Toko, trying to rush and put their stuff in. Folks, although we got an extension, try to get yourselves regularized long before the deadline. As I was telling a friend of mine who is also a client, and I had incorporated a club for her, a swim club, and she called me yesterday to ask me what was the extended date. No, she called to inquire whether the date was extended, and I slipped, and I said yes, it's extended to the 31st of December. And I said, you know what, I should not have told you that. I should have given you the original extended date of the 30th of September, because I know her. She'll wait until the 30th of December and then come and bring the documents and say, Sonji, go and file this for me. So don't wait until the very last minute to get it done, right? So NPOs, other than the companies, the non-profit companies, who are in operation before the commencement of the Act, they may continue to carry out the activity for a period of 18 months. So say you're an NPO that was not a non-profit company, an unregistered body, like a teacher's club or reading club or whatever. You could have still carried out your activities as a non-profit group for 18 months after commencement. But after that 18-month period, you have to make sure and get your business in order, because it is an offense to carry out business of a non-profit organization without being registered. It is an offense to solicit money on the pretext that you are a non-profit organization without being registered. And I can say for sure, you won't get no government funding if you're a non-profit organization and going and say how you have this swim club, basketball club, all the needy things that you could put to the corporate entities and to the government. You would not get any funding unless you could prove that you are registered under the provisions of the Act. Yeah. Okay, this is where I try to upload the form. As I told you, it didn't work. So probably at the end of the, the presentation, I'll try to upload it again. So you have to submit your registration form. You have to submit a complete risk assessment questionnaire. And let me just tell you briefly what the purpose of the risk assessment questionnaire is for. The risk assessment questionnaire is to determine the level of supervision your NPO requires. Remember, the purpose of this legislation is to protect you from being used as a conduit for money laundering and financing weapons of mass destruction or the proliferation of weapons of mass destruction. That is the purpose of this act, is to prevent an NPO from being used as a conduit. So when you answer certain questions, if it is, it raises red flags, like your membership includes some strange characters, we don't want to call names, you know, then they probably might flag you as one that requires heavy supervision. So the risk assessment questionnaire determines the level of supervision you would be required, because in the main, the majority, I mean, I can't speak and I can't put my head on a block for nobody, but the majority of non-profit organizations really carry out purposes that are humanitarian. They ain't really concerned with no money laundering nonsense and no weapons. They probably don't even know what that is if you ask them. But the authorities don't know. FIU doesn't know that. The fraud squad will know that. So it's based on the responses that you give that a determination can be made as the level of supervision that you require. Right? If you are incorporated, you have to submit your certificate of incorporation and your bylaws. You have to submit photographs of all of the controllers of the NPO. I will explain who the controllers are. And then if you got exemption to become a charitable organization, you have to submit that letter of exemption. The Financial Intelligence Unit is the regulator for all NPOs. Obviously, because as I said, NPOs are now listed under the first schedule as a listed business, which means that the NPOs are required to undertake certain things. So you see all of these things here? I am, through my firm, required to complete all of these things because my area of practice is a listed business. Because I deal with the buying and selling of property, the incorporations of companies. So I become a listed business and I'm required to adhere to all of these provisions. I have to make sure that I have created a compliance program to manage or monitor my adherence to the Financial Intelligence Unit regulations. I have to have on board, I have to recruit a compliance officer who ensures my adherence to the compliance program. So it starts with the compliance program, and then I have a compliance officer who would monitor the activities of my services to ensure that it complies with the compliance program. And my compliance officer has to be trained annually. All members of staff of my firm must be trained annually. I have to have my business audited annually by an external auditor to confirm that I am in compliance with the compliance program. I have to make sure that I have implemented proper data capture form to ensure that anybody who is seeking my business, seeking my services, I know their identity and I could confirm who they are. Remember, you don't want to be a conduit, so you have to be able to confirm, put your head on a block and say that this person is this person based on the data capture forms that you have. And you have to maintain a log of any suspicious activity, any suspicious transactions, and not just maintain it and put it in a drawer on their desk. Report it. Remember, I told you there is an offense if you don't report it. Because if they find out that you knew, you would find yourself in a little bit of hot water, right? So, NPOs whose gross income exceeds $500,000 are going to be supervised by the FIU. There's no question about it. So based on your responses to the risk assessment form, if you show that your gross income is over $500,000, you automatically become open to be supervised by the FIU. What comprises your gross income? This is important to note. You might think it's just from the services that you provide. No. If you own a building, There are a lot of charitable organizations that own building and you're renting out parts of that building, the rental income. If you have investments, you have received money and you invested it, Reutering, UTC, wherever you have it, and you earn an interest on that investment, that is your income. If you get any donations or subventions from the government or any corporate entity, that is income. If you get loans from any contributions, that is income. If you get any kind of monetary benefit, all of that amasses to your income. So it's the aggregate of all of that what calculates to the $500,000. So you may not be providing any services that you get cash of $500,000, but the amalgamation of all of these things is what they count for the $500,000, right? So if you're below $500,000, then you wouldn't have that, supervision, so to speak, of under the ambit of the FIU. Who is the controller? Important, because the controller of the NPO is the one who is faced with the liability. When we talk about being in prison, you can't put a building in prison. You put a man or a woman in prison. So if you are using some arbitrary name, pink hibiscus, sorry to pink hibiscus, you can't take pink hibiscus building and put it in jail. It will be the controllers of pink hibiscus that will end up in jail for 5 and 7 years if they fail to adhere to the provisions of the Act, right? So controller of the NPO must ensure that financial accounts and records are kept of all of the cash received, all of the gifts it receives, all of the sums it raised from fundraising activities, any monetary transactions, all the assets and liabilities of the company, of the NPO, and any other matter that they may prescribe by the regulations. And who is the NPO? Sorry, who is the controller? The controllers comprises, one, the directors of the company. So all who are appointed as the directors of a non-profit company, they are the NPO. If it is a trust, remember, you don't have to be a company. You can be unincorporated. If it's a trust, all of the trustees of that trust. If it's not an NPO, if it's not a company, it's not a trust, it's just a club, any person who has management or administrative responsibility for that club, they are the controller. Any senior officer is a controller. And anybody who really exercises any management or control becomes a controller within the definition of a controller. NPOs with a gross annual income exceeding $10 million per year must have their accounts audited in accordance with IFRS standards. So remember when I said earlier that FATF indicated that the standards and measures that you put in place should not be onerous and extensive, whereas they are deficient. So originally, when the first draft of this bill came out, it had that all NPOs had to have their accounts audited under IFRS standards, which means getting an auditor, paying an auditor, sorry to all the auditors here, a heaping set of money, sorry Tammy, a heaping set of money. And if you are a little small little village club, where you getting this money to pay an auditor? So the Attorney General, after we protested, raised the bar to $10 million. So your NPO has to be receiving an income, having an income. You remember we talked about what is the gross income, right? Gross income exceeding $10 million to have your accounts audited annually using the IFRS standards and submitting that audited report to the FIU. So you can't just say audit. So you can't say it and you ain't do it. You have to actually submit the audited report to the FIU. And of course, each action has a consequence. So failure to do it leads to a certain consequence. The controller must ensure that the records are kept in proper order for a period of 6 years. Any controller of an NPO who knowingly and without reasonable cause a contravention of those particular sections commits an offense and is liable on summary conviction to a fine of $50,000 and imprisonment for 7 years. I spoke about this earlier and I want to reinforce it. An NPO, if you purport yourself to be an NPO, that solicits or costs to be solicited contributions from the public or state, whether locally or Trinidad. You could say, I ain't taking no money from anybody in Trinidad. I'm going outside Trinidad. I'm going to Barbados, America. It don't matter. It is an offense. And the consequence of that is that you are liable on summary conviction to a fine of 50,000. So they will forget the jail term. You'll just get the fine of $50,000 because it is the organization that is going to be fined and the controller of the organization are going to be fined. The controller will also be fined and jailed. Yes? So it's double fining going on there. The entity and the controller. So there is an exemption, and the exemption is that if you come together as a group for a particular purpose, but it has to be a single event to raise funds for charitable purpose, you are exempted. So remember we talked about our examples, our housewives in that village in Lingua, in Moruga, that came together to raise funds to send this young man to Yale. If that is all they're doing, one event, one barbecue, hopefully they could raise 250,000 US in one barbecue. They're good. But if they're going to have to do 10 barbecues, 50 barbecues, that is not a single event, you know, it's multiple events. And you have to get yourself regularized. So, you know, sometimes you might have a friend who might be ill and you're trying to organize a little curricule and things to help them out. You're okay. Single event, you're exempted. But it can't be, because somebody had asked me at one point in time when I was presented on this, what about if it's multiple of that event for the same purpose? Event, they didn't say single purpose. The purpose is remain the same, but you're having multiple events to raise funds for the same purpose. So it does not matter. You would be in breach of the act and liable to $50,000 fine and 7 years in jail, clause 22.2, you know. And this person who asked me was a colleague of mine, an attorney. So yes, so single event means the event of raising the fund, not the purpose. The purpose might remain the same, but you are having several events for that purpose. No way one barbecue could raise enough money to send this child to Howard. So you will have to have several events. And that group of housewives, unfortunately, in Moruga, must get themselves regularized under the NPO Act, or else they would be in trouble. The end.
Thank you, Sonji. This was so excellent.
Let me pull up quickly. Let me just pull up quickly before we jump into the question and answers. And I know we're running close to next to time to that 1 hour you give me. Let me just pull up the registration form to just show them what it looks like. And the questionnaire.
Yes.
So I need to stop sharing.
Yes, and then you will share the other document.
Yes, so let me just do that quickly. Okay, so this is the application form for registration. So whether you are a non-profit company, as I said, would have been transitioned to the register already, but they have to complete their registration process. So they are required to complete this form. And if you're a first-time registrant, you have to complete this form. This is what the form looks like. It gives the organization names, the names of the controllers, and a declaration that you have to sign at the end. So if you're lying, you will be liable under the Summary Offences Act for breach of this declaration as well. So you can't tell a fib at all. Okay? And let me quickly get the other one for you. Yes, and the forms, you could actually write on the forms. So although they are PDF, you could these are the actual forms that you have to complete. So you could complete these forms and sign them and submit them with the documents that I indicated earlier. You're required to submit the IDs and the certificate of incorporation and the like. So this is what the risk-based questionnaire is all about. Remember, I said this questionnaire is to determine your level of supervision. Oh, let me back up. This questionnaire is to determine your weakness to be a conduit to naughtiness. You don't want to be caught up in no naughtiness with anybody who are nonsense, promoting terrorism and building weapons of mass destruction, whether in Trinidad and Tobago, Libya, wherever. So the information on this form will assist the Financial Intelligence Unit determine your level of exposure to being a conduit. And if they determine that your level of exposure is high, then your level of supervision will be great, because it means that you have to be supervised stringently to ensure that nobody abuses your entity to carry out these ill purposes. Yeah, so usually it's a long form, is about 10 pages. So it's a lot of things they ask you, you know, how these
Yes.
authorities are. So a lot of information you have to answer to provide a bit of background and explanation on the work that you do and who are your contributors, because that's where the risk is. It's not what you do. Well, I mean, it's what you do to be good. You can't be doing nonsense, but you could be doing good stuff, but you have contributions to up the bad things. So who your contributions are, who your benefactors are, who your contributors are. That kind of answer they're looking to elicit from you to determine your level of exposure. Yeah.
Mhm.
All right. So that, as I said, brings me to the end